I have always believed that the not proven verdict in a jury system where you have 15 jurors and the only requirement for a guilty verdict is a simple majority of 8 of 15. I believe the not proven verdict is a valuable addition, an important addition, because with the 3 verdicts, you have a home available to all the jurors, which most accurately reflects their view of the evidence. Now, if you cut it down to basics, as you and I know, the obligation on the Crown is to prove the case it brings beyond a reasonable doubt, and that's it. So theoretically, if a jury is being asked, what is your verdict? All it's required to do is to answer that question. Has the Crown proved its case beyond reasonable doubt? And that's why I have said in the past that in very simplistic terms, you don't need to use the words guilty and not guilty or anything else. You could simply have yes or no. And part of the problem with verdicts is that we do use terms such as guilty and not guilty, as if that meant something. And it doesn't, of course. If a verdict of guilty is brought back against an accused person, all it means is that that jury on that day thought the Crown case had been proved. A different jury on a different day might have taken the opposite view, but that is the justice system. Where we have the 3 verdicts is that a juror might think, yes, this case is proved beyond reasonable doubt. I have no problem with that at all. A juror might think, no, I'm not sure about this. I think there's something in the Crown case, but there's not enough to satisfy me that it is proved beyond a reasonable doubt. And in that situation, the juror can express that view by the not proven verdict. Or you can have a juror who thinks this case is just a loser from beginning to end. This chap has got nothing whatsoever to do with this crime. I want to vote for the more assertive verdict of not guilty. Now, that to me is an advantage. And unfortunately, it's been presented on too many occasions as if it was somehow a drawback or a failure in our legal system. And the way that has been done is when a not proven verdict has been brought back, very often the relatives of the victim of the crime involved have presented it as if somehow the accused has escaped justice. And that carries with it the implication that if a verdict of not guilty had been brought back, these same people would be saying, what a terrible thing it is that an innocent man has been prosecuted for this crime. The police must now go and find the guilty party. And I'm afraid that's just not true. That's just not right. Because I have no doubt that the family and friends, especially in a murder case, but it applies to all cases, of a victim, will come to the view, because a prosecution has been brought, there's been a police inquiry, that they are prosecuting somebody because the state believes they are prosecuting the right person. But that's not the way it works, because it's for the jury to determine whether or not there is guilt proved. A prosecution simply means you are being prosecuted. But do we really think the relatives of a victim are going to go into a trial thinking to themselves, well, I wonder if they have got the right person? Maybe they've got the wrong person here. So the not proven verdict is being politicized. And far too many politicians have jumped on that particular bandwagon, including politicians shortly before the last elections here. All of a sudden being converts to doing away with the not proven. So I think when we look at it and people understand the significance of the not proven verdict, it is in fact one of the great assets to the Scottish criminal justice system. And to do away with it, I believe, would be to our detriment. As I have said before, however, if I was being cynical about it, If I was interested in success and winning cases, I would be inclined to think, well, let's do away with the not proven verdict, because I actually believe it would increase the acquittal rate. Because if you polarize a jury between guilty and not guilty, ordinary people on a jury, I think, are fundamentally reluctant to convict someone of serious crime unless they are pretty sure they are guilty. So if you're going to have the polarized system, it cannot simply be a majority of 8-7, because if it's 8 of 15 voting for guilty, what is that if it's not reasonable doubt? Because 7 said no. So you would have to go towards the English system of either a unanimous verdict or a much greater majority. So in England, it has to be 12 out of 12, or a maximum, or a minimum, I suppose, depending as you view it, of 10-2. I think that would actually increase the acquittal rate. And I don't think that's in the interest of justice. It's being spun politically by those who have a motivation to claim they are trying to improve the conviction rate by doing away with the not proven verdict.